Hello, ladies and gentlemen. Welcome to an August 22nd edition of the MSP Initiative at MSP Talk. Not in my normal digs, but that's okay. I know what's going on. MSPinitiative.com. That's where you're going to find everything that we do, including a recording of this very session and every other session we've ever done. You will find that under the Sessions tab of MSPinitiative.com, as well as our YouTube page and our podcatcher and audio, video, all of it. You can download, subscribe, share, forward. You know what to do. Definitely get it out there because we like to do these for you. Also on MSPinitiative.com is the MSP Community Minds event. We did one of these back in Nashville earlier in the year, and we are coming up to our second MSP Community Minds, which is an entirely educational event just for IT managed services companies in Denver, September 25th and 26th. So literally not $3.99, $9.99, $12.99. How about zero? Other than you have to get there, which I understand takes time and money, but what else do you have to do? If you need a sandwich from down the street, it's going to take time and money too. So it's entirely education focused. We have MSP panels with people like you who have figured a thing or two out. They may help you. And experts like the person we're going to be talking to today in this session, who are going to actually do more than a 45-minute death by PowerPoint, try and sell you something with a credit card swipe. At the end of it, they're going to take a 2-hour workshop and actually get through something with you, which is more than you've probably gotten in almost every conference that you've probably gone to. So MSP Community Minds, Denver, September 25th, 26th. Check it out. Again, totally for you, totally educational. What do you got to lose other than if you don't want to learn anything? That's cool. You can network. We do that too. Then we have 5, not 2, not 4, but 5 remaining. Oh, that's right. We just finished one of those 5 last night. So if you came out to IT Nation Sydney last night in Darling Harbour in Australia, we hope you had a great time. I saw the photos. I wish I was there. Looked like a blast. We're at Cargo Bar, and looks like we brought our famous block party digs and made it happen down under. However, we have one more of those, so stay tuned. For the rest of the year, we have the remaining 4. That's right, 4 block parties remaining. 1, Pack Day Beyond Berlin. So if you are headed to Germany, we'll be doing one there. Then we have DattoCon in Miami. So if you're headed to the Fountain Blue on South Beach, we're doing one there. Then we have IT Nation Connect, which is the big one we will do every year. And we usually bring a radio recognizable artist. We will announce one soon. Stay tuned, but that is scheduled for this year. And then remember, I said we're coming back to Sydney. We'll be closing out the year in November. In Darling Harbour, funny enough, at the same hotel venue or right next door at DattoCon Sydney, which will close out the year. So if you like some networking, maybe a few beverages and some food, all for free, all for you, the MSP, then you should head over to MSPinitiative.com, go to block parties, register ahead of time so we don't have to remind you as you're standing in front of the door at one of these places. We also have some deals and offers that are sitting on the webpage if you can take advantage of them. And the industry calendar goes until the very end of the year, which if you haven't been out on the road September, October, November of any year, like forget the COVID years, but any normal year, that's when we call it the gauntlet in IT MSP land because everything is happening at once. And if you didn't want to be home for 3 months, you could actually not be home for 3 months. So that is all of the housekeeping at MSPinitiative.com. You can go check it out. I usually share my screen, but not in the normal place. So go ahead and check it out on your own. Looks like we already have a question. Will you have Elvis and the Cowboys cheerleaders? I know who that's from, Keith Nelson. I will have neither the Cowboys cheerleaders or Elvis because nobody knows where Elvis is, but some suspect he's still alive. So without further ado,
but Keith should feel free to come and dress as a cheerleader if he wants. I mean, that's and don't put it past him.
Or Elvis. So
either one.
Without further ado, we bring somebody who's been on this podcast many a time, talking about many a thing, and hearing me rant about my Georgisms from time to time. Although he does bill me for that time sometimes. Here is the IT Channel's probably most famous and well-known attorney in our sandbox, at least, Mr. Brad Gross. How you doing today,
Thank
Brad?
you, George. Doing well. So it looks like you're in an asylum right now with that background there. You got the exit sign, the light. That's good. That's
No, I mean, listen, it's a desk and a place where I can sit down and do this. So
I
that's,
understand.
work from anywhere. That's what they
I'd be
say.
proud of you even if you were at an asylum. That's fine. In fact,
Well,
asylum might be cool, kind of cool, right?
except if you're the guy inside the padded room,
Yeah, well,
maybe
that's true.
that
Yeah,
would be a
you're right.
problem.
Right.
Not to go too crazy down that path.
Mhm.
So Brad, other than, hey, it's been around for a long time and in our industry, was also at not one but two MSP Community Minds events. One last year in Denver, now Nashville. Now we go back to Denver. He'll be joining us September 25th, 26th. And
It's a great event. It's a great event. I'll tell you why. I'm going to cut you off and tell you why it's a great event. It's a great event because you're giving speakers, including me, the time and the venue to actually delve into things that you don't otherwise have time to delve into when you're only given a 40-minute time span, right? Or even a 1 hour. If assuming 1 hour by the time you're introduced and you take questions and so on, it's really like 40 minutes. And while that's okay in some circumstances, if you really want to get into in-depth questions, really the kind of hard hitting, this is what's keeping me up at night, and I'd like to talk about it not just with you but others in the room and collaborate and all. Well, then you need more time, and that's what you've done. You've given everyone, like you said, 2 hours to jump in and just tackle things head on in a substantive way. So I think it's a great event, and I'm happy to participate, and thank you for having me.
no, thank you for spending a little bit of time with us. Now, in these 2-day community mind events, Brad does 2 hour sessions. So if you wanted 4 hours of Brad, which I know what his billable rate is, we won't share it here. That's not cheap. I think you should take advantage of it if you can get it. Which, funny enough, our friend Keith Nelson has asked the question. He said, "Can we engage Brad to evaluate a contract in MSA written by another attorney that was supplied by a client?"
Of course, that's what we do all the time, right? And it's interesting that you assume, sometimes people assume that when they send in contracts for us to review that, oh, we're going to mark it up, we're going to destroy it, and so on. I've stopped trying to predict what the future holds. I have received contracts from clients where they say, an attorney wrote this, so it's probably pretty good. You'll just review it. Okay. And it turns out to be the biggest piece of junk you've ever seen. I mean, just horrible. Okay. Usually because the attorney doesn't understand the industry, but that's another story. Then sometimes we'll get contracts from people that will say, listen, I pieced this together from this place and that place and this place. And I'll look at it and I'll think, well, you know what? This is pretty good. This isn't so bad. So yes, Keith, send it on through or call me, contact me. We'll take care of you. And we'll see. Maybe it's a horrible piece of authorship, or maybe it's not so bad.
Or if you had your contract written by ChatGPT, then you should definitely have it.
ChatGPT. Yes, there's a lot of stuff on AI right now going on about implementing ChatGPT into your company. Lawyers are being pitched for ChatGPT all the time as well. And we could talk about ChatGPT if you'd like, just for a few minutes.
I mean, listen, I've seen things pass by my mailbox where the chat bot of the company gave the wrong information, which led to a lawsuit, and the person who brought the lawsuit won. Or the information that's being offloaded to the AI system, you never got permission to offload it to the third party who now has processed that data, and now that data could be out in the ether like everything else on the internet and not private. So like there are every time we talk about technology, the law always is behind the rate of change of technology. That's undisputed, right?
Yeah.
But and I'm all for the next 3 years is going to be the AI just revolution. Back in the industrial revolution, it's going to be the AI revolution. Okay, that's great. And like, I'm all for bleeding edge, cutting edge, efficiency, all that jazz. But at what, do you put yourself, even unknowingly, which is usually what happens, you didn't realize you're in a bad place, in harm's way by adopting this and putting your data and your customers' data through it, and then all of a sudden a year from now we find out, oh well, that was effectively like leaving your front door open, and you just put it online for the world to see.
Yeah, so it's a great point that you bring up. In fact, I was aiming for a different way of looking at AI, but let's hit yours first. Um, if you actually look at the privacy policies, the terms and conditions, and so on of all of the major AI platforms, from Google, from Microsoft, and so forth, what you'll find is that there's a chance. I'm not going to say a very good chance. That's disingenuous, but there is a chance that the data that you enter into the AI model will end up in somebody else's AI results. And there are ways to shut that off. Okay, there are ways that you can go into the control panel of each AI model and turn it off, so the risk of that happening has been mitigated. But most people don't know that. So you're right. A lot of people are entering in data into AI models right now, not understanding that at some point there may be a reckoning in which you're going to see that data in somebody else's AI results. So yes, if you're using it for that way of doing things right now, I suggest you go into the control panels, turn off, and you could Google it, do a search for how to turn off the data sharing aspects of Gemini, of Copilot, whatever you're using. And I suggest you do it for sure. Go ahead.
So the other example was the company getting sued by their customers because it was an airline, actually. The example was an airline. Their policy was one thing. Somebody went onto their website. It forced them into a chatbot, and the chatbot gave them countering information to the policy, which then resulted in loss, right? Financial loss to the customer. Yeah. And the customer's like, well, your system told me the inaccurate information. Here's what's in writing. Here's what your terms say. Here's what your chatbot said. And now I'm out. And the airline kind of shrugged and said, oh, well, turned into a lawsuit that they lost, apparently.
Right. There is definitely an incongruence. There is a dissonance between how companies are implementing AI and their policies and procedures that they were following prior to the AI implementation. And so what we're finding is just exactly what you're saying, that dissonance, that disconnect is causing mismanaged expectations, information to be leaked where it shouldn't be, and that causes liability. So, again, I'm not saying that the AI technology and the revolution is not going to be upon us, but what I am saying is that it should be taken in steps, not just I'm going to jump into this pool and go all in. Don't go all in so quickly, because you still need the foundation to support it from a legal perspective, from a logistics perspective, from a data sharing and privacy perspective, for sure.
So what happens if, we've seen PSAs, RMMs, different tools in the MSP IT industry who have added functionality, right? Like, hey, you can ask the AI ChatGPT to write a script for your RMM. And didn't say it was good, but you can surely do it. They now offer that. Yep. And so now all of a sudden, or hey, now I'm going to start taking all of my ticketing data. I'm going to route it through some AI engine that now has all your notes, all your communication, maybe passwords in there, which maybe not the best way to share passwords, but maybe they're in there. And then what about the people who are like, hey, I'm suing you because you took my data that I understood to only be between me and you. And you're now sending it to a third party without my knowing, and I didn't give you permission to do that. Now, what happens in that situation?
So what you're talking about is exactly what I was implying earlier about the legal ramifications of using AI. MSPs, any industry, any service provider, but obviously we focus on managed service providers, MSPs, TSPs. They would be well advised, to update all of their service agreements and their customer facing documents if they're thinking about doing exactly what you just said, implementing AI solutions, because there are known risks and then there are unknown risks, and all of which at least should be discussed with the customer. This idea, by the way, of an MSP saying, well, you know what, this is great. I'll update my document and I'll post it, and that's it. Right? That's it. I'm just going to update my document, or I'm going to send them all my customers an email. We've updated these terms, by the way, and this is what governs our relationship now. Okay, you can't do that. Okay, so on the one side, you're well advised to update your agreements. On the other side, you have people with pundits, even legal pundits in the industry, unfortunately, saying, yeah, just update your agreement, and your customers, they have to check back to make sure that they understand what's no, 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 no. One party cannot unilaterally change the material terms of a contract and then force it on the other side without the other party's consent. They'd say, but credit card companies do that, right? Microsoft, all these companies do it. They update their terms. They say, here we go. They don't. They don't. What they do is something more nuanced. What they do is they say in their agreements, they say, look, we can update our terms by providing you with advance notice of those changes. And your continued use of the service after that notice in the future, after that notice date in the future, indicates your acceptance. However, and this is the big however, and this is what MSPs need to think about as they're updating their agreements to accommodate AI. However, if these companies always say, if you don't agree with the updated terms, right, then you have the ability to terminate your relationship with us without further liability. You pay us what you owe us under the old agreement, and you're out, right? If it's a credit card company, they'll say, pay us what you owe us up to that date. Stop using our card. We're done. Stop using our software after this date. We're done. The problem, okay, with MSPs doing that is it doesn't translate well into the service industry. Why? Because MSPs are unique in that they have upstream providers to whom they have made promises. They have made commitments, right? Without endorsing. I'm not endorsing, but right, Datto might require a long-term commitment. Microsoft NCE, Cisco Meraki, all of these paradigms require MSPs to get locked in upstream. You don't then want to turn around and tell your customer in month 5 of a 36-month agreement that in month 6, you're going to update your terms to include AI and so forth. And if you don't like it, get out. Because you know what they might do? They might go bye-bye and get out. And now you, the MSP, you're stuck paying all those fees from month 6, 7, 8, 9, 10, all the way to the end because you let them out. So as MSPs update their terms to accommodate AI, which they should be doing, they need to ask for the parties, their customers' consent. They need to do it through natural touch points, maybe renewals, right? And that's when you can implement these new documents. But you can't just willy-nilly jump in and update your terms and say, this is how it is.
Interesting, because there are other people in MSP IT land who have adopted this idea. Mm-hmm. And I agree with you. I would say that more MSPs have adopted a termed relationship rather than an ongoing get out whenever you want relationship. I know that they both exist, but I would say majority have now switched on to a clock because they are, being forced on a clock upstairs, like you just mentioned.
Yeah.
So at the end of the day, what you're saying is that you have to have a fractured implementation because your customers may take a 36-month or 46-month or 56-month or however long it takes for all of your contracts to roll over in that methodology before they can implement it across the board.
Right. A fractured approach works. Or, MSPs can also just not leverage the volume discounts or the subscription discounts that they get for things like NCE by going month to month. Okay, well, then you don't care, right? Then you can update your terms and say, if you don't like it, get out. Well, you had a month to month anyway. But when you're bound to upstream, MSPs are quick to forget that they have commitments upstream and that those commitments are going to be fulfilled, right? PAX 8, all kinds of commitments upstream. Those are going to be fulfilled by the MSP, whether it has its customer or not. So you don't want to give the customer a backdoor to get out. No, and that relates to AI and every other change that you make to your agreement.
That's fair. That's fair. Yeah. And I want to pivot real quick. Maybe nobody wants to hear the word CrowdStrike anymore, but I haven't had a chance to talk to a legal person about it. So here's our chance. Okay. So I've heard you say myself, many times, hey, like patching and updating and making sure that you have, everything on the current up-to-date version is important, and you advertising those services and not doing that, it's going to come back and bite you. And this is what your contract needs to say. Because, you are delivering that service, et cetera, et cetera. Well, how about everyone who did deliver that service and did update and then crashed it?
And then it got crashed. Yeah, that's a problem, right? Maybe. And I'll tell you why. So we have to first divest ourselves of the notion that just because something goes wrong, there's going to be liability on the MSP's part. Okay, we're going to have to get rid of that idea. I don't know who convinced the industry that if something goes wrong, it's definitely your fault. You're going to have liability, MSP. Maybe it's the vendors, right, who are selling their products and their solutions, saying we can prevent things from going wrong because if anything goes wrong, your ass is on the line. Okay, I think that isn't. We have to get rid of that idea. The concept, okay, that we're going to focus on just for a minute and talking about this issue and CrowdStrike in particular, is that MSPs have a standard of care that they have to adhere to, whatever the standard they have established, but it's a reasonable standard. They have to provide the services that they said they're going to provide or facilitate in a reasonable manner. Okay. And we can argue about what's reasonable and what's not reasonable and so forth. But for the moment, let's assume that you have an MSP that's providing an RMM, BDR, EDR solution with some security awareness training and so on. It's all there, right? Comprehensive plan. And everything is running as it should. Everything is installed. If you're using CrowdStrike, the agents are in there. It's running as it should. The patch is delivered. You update it. Suddenly bad things happen. Not from what you did, but from the upstream provider. Okay. Mm-hmm. We're going to start off by saying that MSP doesn't automatically have liability. Why? Because it's following a reasonable standard of care. Well, did it implement the solution? Yes. Is it a good solution? Yeah, it is a good solution, right? Okay. Did you, MSP, have something to do other than following industry norms of updating critical patches and so forth? Other than that, did you do something to crash the system, to cause this problem? No, right? It was the upstream provider. Okay, so where's the breach of your duty? There is no breach, right? You're adhering to the standard of care that you should be. You're acting reasonably. You're implementing the solutions. You're updating them when they're supposed to be. But something happened upstream. If you are immediately thinking that, well, now I'm going to have liability because this happened. No, you're not. And that's just people trying to get you scared. You're better off following the industry norms, implementing patches, doing what the upstream providers tell you to do, because if you didn't, that would be a deviation. Now you're breaching a standard of care. But assuming that you're doing everything right and everything's running properly, no, I'll take it to the mat all day long that an MSP won't have liability. Okay. But it dovetails into a related issue, which is, what does your agreement say about that? Does your agreement specifically tell your customers, that you are using third-party provider solutions, and those solutions can fail? They might fail, right? And if they do, we, the MSP, we're not taking liability for that. We're not going to take liability in the same way for an upstream provider's service as we would for a service that we actually provide ourselves. Okay. By way of example.
Well, it doesn't, but hold on. Doesn't this get muddy? All right. So the MSP chose the solution, implemented the solution, did everything they were supposed to. Then CrowdStrike happens. It takes them a month to touch all their customers now, because there's only so many employees. There's less employees than there are customers being serviced. Now, all of a sudden, it's going to take an exuberant amount of time to get back to functional, right?
Right.
So now that there's a wrinkle where, well, that part of the service, remediation, is part of what you deliver. And so even though somebody else caused the root problem, I still need you to resolve that problem within a timely manner, and you can't get it done fast enough for me.
Right. Well, first of all, your point, which is a good one, also assumes that remediation is part of a service. And again, I would caution MSPs that when they're drafting their statements of work, their proposals, and so on, make it very clear whether diagnosis and remediation is included, or diagnosis is included and remediation will be discussed. And a separate scope of work will be determined for that, because MSPs, that I always find it curious when they include for this critical level, we will remediate within this period of time. How could you possibly say, like you just said, what if CrowdStrike incident happens? You're not remediating within that period of time. So I would always caution MSPs to not go down that road. But what you're saying is, and I'm going to repeat it so we're all on the same page, is that while the MSP might not be responsible for CrowdStrike crashing, okay, or crashing systems, it is responsible potentially for creating a workaround, getting the customer up and running with some other solution in some period of time. And you're right. And you're right. And that gets down to what your MSA, your agreement with your customer, says. You can say, we're not responsible for an upstream provider's failure, okay, or the consequences of that, okay, but I'm still your customer, right? I still need an endpoint protection solution. I need something. Yeah, what does your agreement say about that? Does it say we will try to implement a workaround as promptly as we can? Or does it leave it silent? If you've left it silent, then you're right. You're going to have the customer saying, well, fix it. Well, I can't fix CrowdStrike. Well, fix it with something, right? And if you can't act quickly enough, yeah, then it might be viewed as breaching some sort of standard of care, for sure. That is why I've preached this for 23 years in the industry, and I continue to. MSPs, when they're thinking about these customers, need to think about reality-based contracting, reality-based. And you just brought it up, George, and you hit it right on the head. It's one thing to say, well, legally, I'm not responsible for what CrowdStrike screws up. Okay, that's legal. But what about the reality of something needs to be done? Right? The reality of you've made promises that you're my trusted IT advisor and you're not going to leave me hanging. Now what? That's reality. And so when you're thinking about these contracts and scopes of work, I implore MSPs to think about realities, worst case scenario, and address those, because that's usually more important, candidly, than the legal stuff.
Well, I'm going to get back to a response to that real quick, or a follow-up, but Keith Nelson chimes in. He's like, can you write up an uptime warranty or some sort of exclusion for things like, acts of God, power outages, internet provider outages,
Sure,
upstream failures, etc.?
Sure. Well, what you're talking about, Keith, is a force majeure, right? Act of God, war, sabotage, and so forth. And again, that gets back to, well, that would prevent someone from saying a third party messed up and it's on you, okay? That's a force majeure. We couldn't stop that from happening. We were doing the right thing and so forth. Okay. But it is not a force majeure where you have promised a customer prompt workarounds or prompt remediation. You can say, well, it's a force majeure. CrowdStrike screwed up. Okay. Well, there are other vendors. There are other solutions. I sort of have to wait until CrowdStrike resolves itself. No. That's not a force majeure. A force majeure impacted the initial assessment of the situation, but moving forward, you have lots of options as an MSP, and you're not going to be able to resolve them or rest on, hey, it's a force majeure that happened way back when, so now we're just going to sit and wait. Oh, no, that's not a force majeure. That's just the MSP failing to live up to its contractual obligations.
I mean, so back to, again, using CrowdStrike, like this was advertised as the largest global IT outage in the history of recorded history. Is there an argument to be said? It's never happened before. We didn't plan for it because it's never even been in the spectrum of planning. It's never happened.
So that makes it a force majeure, the initial assessment. Let me give you a more down to earth analogy. Okay. What if I said to you that as long as you're in my house, you will be able to walk from the bedroom, okay, to the front door without crashing into things. Okay. As long as you're there. Okay. And what happens at night? Well, turn on the light, right? Light switch is available and so on. Okay. Now the lights go out. There's a lightning strike, force majeure, act of God takes out the transformers in the neighborhood. Lights do not work. There's nothing I can do about that, right? Okay. So you might say at this point, hey, at this moment, I can't walk to the front door. I'm going to crash into things. That's a force majeure. But What other options are available to me? Flashlight? Candles? Huh. So if you say to me, Brad, you have flashlight? No. Candles? No. That's a problem. Now I've breached the standard of care. Okay. Because I've made you a promise and I'm not implementing reasonable workarounds that are obviously available to me. What am I going to say? I'm just going to wait for the electric company. Sorry, George. No, at some point, it leaves the spectrum of force majeure and enters the spectrum of you're just not doing the right thing here. And so, to your point, when CrowdStrike occurs, all right, the CrowdStrike incident occurs at that moment, maybe for a period of time after that, while everyone's trying to get organized and figure out what's going on, that's a force majeure. But clients are not going to sit back, nor should they be expected to sit back and wait for that to resolve itself. You as an MSP, you have to come up with a workaround, some workaround. It might not even be as good as what you promised CrowdStrike, but you got to come up with something.
So and this goes back more to just general stuff, but I'm just going to continue down the line of thinking. So I wrote up my agreement, my scope of work and my MSA in a way that says, I will do this best effort. I'm not going to give you a timeline because I just don't know what the situation is. So because I don't know the future, I'm not going to give you something that, a guarantee or a promise because I just don't know. So it's just best effort. But if my best effort is a month from now, technically, I may not be against what the agreement says, but my customer may say, this isn't good enough for me, and now I want out.
So what you're doing is you're relying on ambiguous wording, right? That might be in an agreement about, I'm going to do my best efforts. Well, understand this: in every agreement, in both the consumer space and the commercial space, okay, business to business, business to consumer, there is an obligation of reasonableness built in. It is, even if it doesn't say it, there's an obligation of reasonableness built into every contract in the US. That is contract law 101. So you say, I'm going to do my best efforts. Well, what are best efforts? You have to act reasonably. If in this case, going back to my light outage example, my best efforts might be, hey, look, the lights are out. I know I have candles here somewhere. You got to give me a couple hours to find them. Right. And then I actually try to find them. In the meantime, you can't walk because you're going to hit some. That's best efforts, right? That's reasonable. Everyone's acting reasonably. Best efforts would not be me sitting on a chair going, well, lights are out. Let's see how it goes in a week or two. That's not best efforts, right? You'd say, well, that's my version of best efforts because I don't want to walk and fall down either. No, that's where the friction occurs. That's where you're going to get lawyers' letters and so forth. So I think that even when you're using best efforts, that means that you still have to get up and do something, try to do something, I should say. It may not be successful, right? I might look around in the cupboard, can't find a candle, might look around for hours, can't find a flashlight. In the meantime, you can't walk across the house. That's best efforts. There's no breach there. But sitting on your butt doing nothing or waiting for a third party to resolve itself while your customers sit there and flail, no, that's not best efforts. That's going to be that in my view, that's going to be a breach of a standard of care.
Okay, but back to CrowdStrike real world. Mm-hmm. This was doomsday. Wasn't really remediable remotely in most cases. You had to touch. Like I was in airports. I saw people getting up on ladders to connect to the little computer on the back of the TV that tells you what they're.
Unless you were in Southwest.
Oh yes,
unless you're flying Southwest.
Which they're still running on Windows 3.1 and they were unaffected. Right. We'll get to that in a second. But bottom line is, this was, hey, especially the MSPs who are taking on clients that are not geographically close to them, or maybe you're taking clients on in multiple states, right? And you're largely handling that remotely. You're not geographically near them. Maybe it's just I don't have the capacity to get to 100% of my clients in a short period of time, which I would argue for most MSPs, Brad, is actually the case.
Yeah, you're right. And depending on the circumstances, like I said, best efforts changes. It is not a clear-cut definition of what's best efforts in one scenario is the same or transposes to another scenario. And you're correct that if an MSP has a relationship with a geographically distant client and remote access or remote remediation is not available, then you're right. Best efforts in that scenario might be to either wait for a workaround or wait until we could get a technician out to your location to figure out something else. You're 100% correct. And what your point really is that it's fact sensitive is what you're saying. And I agree. It's fact sensitive. But what you'll often see or hear horror stories about is MSPs that try to take advantage of that language and sit back and do nothing. Maybe they're paralyzed in fear. Maybe they're paralyzed because they don't know what the hell they're doing. Okay. And they don't implement a proper solution in a timely way. They're not always going to be able to claim best efforts. But you're right. Sometimes you can, sometimes you can't.
What about the follow the money situation? Let me explain a little bit further, right? Mm-hmm. I decided what vendors I put into my bundle of services. My customer said, I trust you. You're the professional. If you say I need this, then I'm going to buy that. Well, now, CrowdStrike, let's say in this case, they're like, well, I never paid CrowdStrike directly. I paid you and you paid them. So now I need to come to you and we need to have an issue so that you can turn around and go to them and, follow the money, right? So mm-hmm. Isn't that how it usually works, or do I got it wrong?
No, you have it right. What you're focusing on for those who are law oriented is a concept called privity, right? Privity means the relationship, the contractual relationship between two parties. Privity is a direct relationship. If you and I are in a contract, okay, and you're providing phone service to me, and if my phones don't work, and as a result, my customer can't reach me, can my customer go after you? No. Why? Because you're not in privity with that customer. You're in privity with me. So what your point is that if you have CrowdStrike as an upstream provider and you're the MSP, that you have the relationship with CrowdStrike, and CrowdStrike goes down and your customer has a problem. Can the customer go directly to CrowdStrike? Probably not, because there's no privity. And CrowdStrike likely wouldn't accept that kind of a relationship anyway. So you're right, they would have to go through the MSP to get to CrowdStrike. However, the MSP could turn around and say, hey, in our contract, we say that we're relying on third-party contractors, third-party service providers. And if they fail or something goes wrong with them, assuming we didn't cause it, we are not liable. Okay, so what remedy does your customer have? And the answer is very limited, very limited. And that's the way it is. If the customer's lawyer can figure out some fancy way to somehow circumvent the privity argument and go sue CrowdStrike directly, maybe it can be done, great. But you are 100% correct in that remedies are limited. In this type of model, everyone is protecting themselves at every stage. So the person, the end user, the end customer has, if everyone else has done their job correctly, the lawyers have done their job, that end customer has very limited options to go after the MSP or CrowdStrike. Yeah.
Okay. So let me ask you, you always say never, back to this exact conversation, never open yourself up to liability that your upstream provider has reduced. Meaning, if CrowdStrike's service agreement says that you can only go after them for 1 month of billing, whatever the invoice is for 1 month of service. So if that's $1,000, even though there's $10,000 of business interruption, you can only come back and ask for a refund, or you can only come after us legally based on what the contract says for 1 month of service. Why wouldn't the MSP implement a similar strategy to their customer, limiting what they can come after them for?
Well, they should. They should. First of all, it's interesting that your analogy of 1 month of service, and I don't know that CrowdStrike does that, okay? But let's say they did. It's likely an unenforceable limitation. There's a case exactly on this point out of California from about 5 years ago in which Yahoo, it's called In Re Yahoo, for those who want to start Googling it, in which Yahoo experienced a series over about a decade, a series of security breaches in its Yahoo Mail, its email service. And those breaches led to some pretty disastrous consequences. And so consumers who were using Yahoo services sued Yahoo and said, you're responsible for all these damages. And by the way, you've known about these problems in 2010, in 2012, in 2014. You knew about them. Yahoo's primary defense was, you guys signed a EULA or accepted a EULA. And that EULA says that our liability is virtually zero should these kinds of things happen. Virtually zero. It's nominal. So as a result, they argued to the court, this case should be thrown out because there are no real damages. Even if we did what they said, there's no damage. They can't collect anything. The court turned around and said, no good. No, 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 no. You provide such an important service that has so many ramifications to it that we as a society, we are not going to allow you to limit your liability to the point where you have no liability. Okay. And they sent the case back down to the court to now figure out damages. This is also, by the way, being echoed in that executive order that came out about a year ago or so from the Biden White House, in which they talked about the fact that that it's going to be a policy that at least his administration and maybe Kamala Harris's administration, whoever goes through, if it's a different administration, I don't know if it's going to happen, but they announced that it's a policy that they are not going to allow upstream providers to get out of liability through, complex or hidden language in contracts. They said it's not right. Okay, that's as far as it went so far, but that was actually a policy that was sent out by the White House. So my point is that an MSP is not necessarily going to say we're only liable for a month of service or a few weeks of service fees. It's probably going to be deemed unenforceable. That said, all of that. Now let's go back to your question. Upstream provider limits its liability, right? You as an MSP should realize that if you don't have a remedy upstream, you better sure as hell look at your documents to make sure your downstream customers can't come after you for more or at least too far in excess of what you're going to have to pay up. So, you're going to get upstream. Yeah, we see it often. They don't read their upstream provider contracts. They don't, and as a result, they don't disclaim or exclude things in their own agreements. And when the customers come after them, they look up and they're like, for the first time, they realize, oh my God, did I limit your liability? Did I agree you're not responsible for all these things? Shoot. Now what? Well, now you have an insurance claim, don't you? That's a problem.
I got one more for you that kind of falls along this conversation. So, did you hear last week? A man took his wife on vacation to Disney. She told them that she had an allergy at one of the Disney restaurants. They swore up and down that they were excluding anything in the meal preparation that would fall within her allergy request. And they screwed up and she died. And now Disney's saying that, well, when you signed up for a trial for Disney Plus 5 years ago on your PlayStation, husband, you agreed that any Disney company would be held harmless. I was like, well, wait a minute. I signed up for a digital streaming service. What does that have to do with your park, which is probably a separate company? Oh, and by the way, you were very negligent, right? Like I asked you, and you told me yes, and now I died. So now what?
Right. I agree with you.
Doesn't this fall into the same thing?
Of course it does. And look, what you just saw was legal acrobatics, right? It was the legal Cirque du Soleil of excuses about how Disney is trying to exclude itself from liability. At some point, reasonableness, acrobatics have to yield to reasonableness and logic. And that's what you're going to see. This case is never going to be dismissed on the basis that they signed an agreement for something entirely different with a company that may or may not even exist at the time that they signed that agreement, right? Disney always has these new entities that they're forming for, single purpose entities and so forth. And to think that a customer is now going to have to take the due diligence that every time it deals with Disney in any capacity, no matter how disparate, no matter how distance it is from the original service, they now have to check to make sure what the ownership is and so on. It's utterly ridiculous. It was something that was interesting and fun to read about if you're doing some sort of mental acrobat there, but in reality, yeah, I wouldn't bet on it.
Okay, so we'll follow that one. All right.
Yeah, I think so.
I hear you decided to get into the software business. Tell us, what are you cooking up over there?
The software platform business. Yes,
Okay.
I did. And by the way, I readily admit, I've told you in private, and I will say it in public. You're one of the reasons why I did that. So you convinced me that I should be, that there's a need, and I saw the need too. But you, in talking with you, were definitely one of my people that advised me on that, and so thank you for that. You are well beyond your years as far as foresight and experience, and I mean that. So what are we talking about? We're talking about MSP Terms. MSP Terms is a platform that I have created that is launched, but we are going to be doing demos of it and then having registrations starting next week. It is a legal document platform engineered for MSPs. Under the basis that I understand the unique contract challenges that MSPs face, right? From negotiating complex service agreements, to ensuring that agreements are tracked and logged, to ensuring that they are offered to customers when they should be offered, and that that they say what they're supposed to say, and so forth. So what we've done is we have created this platform that is going to give its subscribers a whole lot of options, a whole lot of functionality. First, it will allow its subscribers to post documents on their own into what I'll call like parking spaces, online parking spaces. And each space will have does have, I shouldn't say will, I'm so used to saying will, but now it's developed and it's up and running. Each space has its own access level, its own security. And as an MSP, you can then send your customers to view those documents with access privileges. The idea being that I might have a document up there for an MSA for all of my MSP clients. Okay. Maybe I also have a copier business on the side, and I want a different MSA for that. Great. You're going to have that posted on this site as well with its own access level. And the concept is that you're going to say to your customers, if you want to see our MSA, it's located here, boom, mspterms.com/your company's name with a password. And when they get to that URL, they're going to enter the password, boom, the contract's going to appear. They can view it, they can accept it. One of the other unique features of this platform is that your customers are also going to benefit from this. How? Right? How do they benefit? Well, what I have found over the years is that customers are sometimes weary of online contracts. Why? Because how do I know the contract that I accepted on your website is the same one that I accepted 6 months ago, right? How do I know you didn't change it? What happens if your link disappears? Now I don't even know what I agreed to. Well, MSP Terms addresses that issue by giving every customer who is asked to view or accept a document from an MSP its own free platform, its own free account. And every document that it views, accepts, prints, anything from the MSP goes into the customer's account. And that customer account is like a lockbox. The MSP cannot touch it. The MSP cannot change it. So, for example, if a customer accepted your document, right, it would go into that customer's account. Now, let's say, you change your document, you post other things, and so the customer always can see that document that it accepted. It can print it. It has access to it. It will know when it viewed it. It'll have log and tracking abilities, as will you as the MSP. You can log and track when your customer views this document, even in the future. When it accepts the document, when it prints the document, all of that's going to be tracked. So we have this incredible document management platform. Okay. That's the primary offering. It also has a library of pre-built customizable templates, all curated by me. Okay. Not hand-me-down documents, hand-me-down templates, general junky documents that only tangentially apply to the MSP industry. No, these are curated documents from Brad Gross, applicable to the MSP industry. Each can be downloaded, modified, and then uploaded to your account, the MSP's account, and offered to its customers, again, with privilege and access levels. Then there's also a educational component. So the educational component has videos that are
Uh-oh. I think maybe we lost me or we lost
technical
Brad.
difficulties.
Yeah, I think we lost Brad.
address business needs
Oh,
and
there we
business
go.
points that you do. What's that?
We lost you there for a few seconds, Brad. Rewind for a second.
Okay. Where did you last lose me?
Educational.
Educational component. Oh, sorry about that. You missed everything. It has an educational component where we are going to have videos that address the business points that often confuse or are very vexing to MSPs. Okay. Such that, an example might be, how do you negotiate a situation in which your customer says, I want you to get rid of your limitation of liability, or I want you to change it. I want you to take on more. What should you do? It's a good question. We have a video on that issue. How about pricing increases? How do you negotiate those terms? How do you put it into your documents to make sure you're always protected? We have a video on that. How do you implement governing documents like a shareholders agreement, an operating agreement for your company? How do you treat your company like a company? We have a video on that. So not only do we have this platform in which you can store, access, offer documents to your customers, not only do you have a repository of Brad Gross curated documents, but now you have an educational component as well. So that is the platform. And if anyone wants a demo of it, if they want a demo of it, send an email to info@mspterms.com. info@mspterms.com. We're going to start doing demos next week. And again, George, I really appreciate you not only bringing it up, but you were definitely one of the motivations for me jumping into that. So it's fun. It's exciting.
I am happy that I talked to an expert, and sometimes the expert's really good at what they do, but I could add some interesting ideas into the mix. That makes me feel good.
For sure.
And I never said I was an expert of anything. I just come up with good ideas from time to time. But one thing's for sure, Keith Nelson, I think I'm an expert in Philadelphia sports. So does my views of the NFL get included in Brad's educational track? No, you can come here to MSP Initiative podcast and we'll tell you all about what I think about football. Or I would be
willing to do that.
Or
I'd be willing to do a video on that.
Or we can just do it over a beer. Either way. The NFL season is upon us for sure. And a reminder that the NFL season opens up in Brazil. Eagles, Packers. Just to let you know. Anyway, go ahead.
No, we could Photoshop this video to remove just the emblem on your shirt, and then you're wearing gangrene, baby. You're wearing gangrene. Okay. JETS. I'm just not that I would do it, but there is AI that could probably work this out. I'm just saying.
Fair. Yeah. Well, this session was absolutely recorded. If you want more of this, by the way, I could talk to Brad for a long time. Sometimes it comes to the bill, sometimes it doesn't. All that being said, how about I give you Brad's time for free? You come to Denver, September 25th, 26th. This guy's going to be in front of you. He'll take any topic. He'll go through it. He'll work through the whole theme. He has 2 workshops, 2 hours at a piece, 4 hours of time. I was like, I know exactly what that costs. Now, that doesn't include the fact that we had to ship Brad to Denver, and that has a cost too. But that being said, take advantage of the fact that you have an expert and experts in front of you, and we're literally giving you the ability to talk to the people that are in business doing what you do, or the experts that understand this business, which I would argue, and a lawyer that knows a lot about our specific industry versus a lawyer that does a general practice with everybody, you're going to get a different answer. You get a different document. You got to get a different advice. That's what I think is going to happen. You know, we'll see. But I challenge you to find your way to Denver, September 25th, 26th.
For sure.
Or,
And if they think, by the way, if they think that they're just going to hear, oh, well, it's about agreements and all, I could tell you, because you've given the venue, you've given us the ability to talk about anything that's on their mind, legally oriented. Last time we were there, we had discussions about trademarking an MSP's name, how it can be enforced, right? We had discussions about non-compete and non-solicitation agreements. It wasn't just about, an MSA. So the benefit is you get 2 hours, and anything is on the table. So
beautiful. Yeah. Thank you for coming, Brad. Can't wait to see you in, I'm sure I'll probably see you before Denver, but if not, I'll see you in Denver. And yeah, if you are stuck in CrowdStrike land and you're in the middle of some sort of crazy situation with your customer, if you haven't already talked to a lawyer, might be a good idea to talk to one. And check out mspterms.com, brand new. Check it out. What do is it better than what you're doing? Is it the same? Is it different? Learn. What do you got to lose? Check it out. This session was recorded. You'll find it at mspinitiative.com under sessions. Thank you for stopping by, and we'll catch you on the next one. Thanks, Brad.
Thanks, George.
All right.